I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for this introductory lesson on state open meeting laws. As a reminder, all of our classes build off one another. So if you haven't already, please view our previous lessons on open meetings and executive sessions. They'll give you a good overview of the law and lead into what we'll be discussing today. We also have a growing library of lessons on state public record laws and the Federal Freedom of Information Act. All these lessons can be found on our YouTube channel, as well as in our FOI guide at nefac.org/FOI guide. Before we begin this lesson, a special thanks to those helping us make these classes happen. The Society of Professional Journalists Foundation, SPJ New England, the Rhode Island Foundation, and the New England Society of News Editors. We appreciate everyone's support. Now, to introduce you to today's instructor, Emily Sweeney.
Hey everybody, I'm Emily Sweeney from the Boston Globe and the New England First Amendment Coalition, and I want to thank you all for joining us for this webinar, which is part of our ongoing series on state open meeting laws. Now, this session is going to focus on citizen participation in government meetings in Rhode Island. And with us is Ray Marcaccio, and he's going to explain about making public comments during open meetings and give some tips and advice for citizens who would like to make their voices heard at those meetings. So Ray, hey, thank you so much for joining us today.
My pleasure. So as Emily said, this is a pretty narrow topic, and I'd like to just, what we have here is a distinction between your right to observe any of your government proceedings versus your right to participate, whether it's by asking questions, making comments during those government proceedings. And those rights are quite different, frankly, in our state. Not in all states, but in Rhode Island, they are quite different. So with respect to the right to participate, we'll get to that in a minute, but many of you or some of you have already seen the webinar we did with respect to the basic statutory layout for access to public records. So I'm not going to repeat any of that right now, but suffice it to say that the rights to access to the meeting, which are under the Open Meetings Act, which is under Title 42, Chapter 46 of the General Laws, you have your codified rights for everything dealing with public meetings for public bodies in the state of Rhode Island. And those are well laid out. But there are a few other rights that you have by statute that are less known, but can come into play sometimes. And those are found particularly with Title 45, which deals with the meetings that are held by town councils and all town meetings. And under one of those statutes, all town meetings by law are supposed to be open to the public. And you can even, if you're a member of a particular town, by statute, you can even essentially require your town body, your town council, to meet on a particular topic. So if 10% of all of the voters eligible to vote in the last election, that's your basis, if 10% of those people sign a piece of paper requesting that its body, its government body, the town council, meet on a particular topic, they have to do so. And that's something that a lot of people really don't realize. And frankly, I don't know of any time that's been used, at least in my years of practicing law. But that is there. And when I say a piece of paper, the statute doesn't say that you have to have some kind of a ballot question or some kind of an election or some kind of a vote. It just says, get people together to sign the paper, present it to your body, and tell them they have to meet, and they have to. So those are just some of the background statutes and laws that require or give you the right to observe what your government is doing on your behalf. And you should always have that right to do so. And bear in mind, again, getting back to the access to public records, the Open Meetings Act, bear in mind that the first thing you need is to have notice that the meeting is taking place. Otherwise, you can't participate in any way. And the General Assembly has made clear that when a public body is going to meet on any topic, its agenda for that meeting must be specific enough so that a reasonable reading of it can tell the audience what will be discussed. And more litigation, more and more advisory opinions from the Attorney General are coming out that go in that very topic, which is making sure the public even knows that the topic will be discussed at a public meeting. So if a court were to look at that agenda and not really know exactly what is going to be discussed, it very well could find that the agenda is lacking. And any vote that's taken at that meeting, when you're not even present, when the citizens aren't even present because they didn't even know that the meeting would go into that detail, well, any votes that are taken can be voided by the court. Void ab initio, which is just a Latin term for saying it never existed. They've got to reconvene with a proper posting, the proper detail on the agenda, and then the public can observe what's taking place. When that public body closes its door for the executive session, the courts are even more strict because now there's no way for you to know what's happening. So the agenda item must be clearly specified as to what will be discussed and why it's being excluded from public observation. All of that's been discussed. I've discussed it. I'm sure others have through NEFAC for Rhode Island dealing with the Open Meetings Act, and there are other webinars on that. So focusing then on the participation, I think it's a good way to think of it is there's a difference between town hall and town square. So what's going on at town hall, your government functions, would be viewed as a limited public forum with all kinds of restrictions being allowed on time, place, and manner, on the citizens' ability to actually speak and participate. And that's very different than when you look at a town square, a classic place that is for the public to be able to express itself on any topic it wants to, and without any restriction, with almost no restrictions on what is being said, how long you're speaking, how loud you're speaking, or anything else. That's your right to express, and in that public forum, the classic traditional public forum, your rights are strongest. Here in town hall, it is different. Okay, so when you try to think about what you are allowed to do when you see your public body up there voting on something that you are strongly opposed to, and you want to be heard before those motions are voted on, it's going to depend on whether or not that public body is allowing you to speak. And it has to do so through its agenda. So if an agenda has on it public comment for each of those motions, then you're allowed to speak. Again, the body can restrict how that's done, far more so than anything that takes place right outside that town hall on the town square. And that's important just to keep in mind. So if it's reasonable to restrict comments to 2 minutes because you have a lot of people, if it's reasonable to restrict your comments not to everything that takes place in the town government, but what's on that agenda, and those will be found by the courts to be appropriate restrictions on your ability to even say anything at the meeting. And of course, the corollary is also true, and that is, if there's nothing on the agenda that allows for public comment, then it's entirely within the discretion of that public body to even hear you. So if there is public comment being allowed, everybody should have an equal opportunity. There should be no disparate treatment of anybody, which is a little different than saying anyone who wants to speak can. So for example, if there's a topic being discussed for a motion at that public meeting, and somebody gets up and lays out a good argument as to why it should be supported or opposed, if the parliamentarian, usually the chair of that body, gets up and says, okay, does anyone else want to say anything in addition to that? People don't raise their hands because it's actually basically just what they want to say. They just want to they want to repeat exactly what the first speaker said. Probably can be restricted because of the government function that's taking place. The function is to perform government acts, not necessarily to listen to every iteration of the same comment. That's different. Again, town hall versus town square, very, very different analysis that a court and therefore the public body should go through. So I just want to make that pretty clear. When the restrictions are done on your ability to speak, you might want to even ask a question, but definitely on a comment you want to make before something is voted on, for example. Those restrictions will be upheld so long as they are neutral, applied across the board, and are done in a way that the public would know that the restriction will take place. Sometimes, in my view, some words like, with appropriate public decorum is really open to debate. It really is. I mean, I know that's used a lot, but just think about in your own experience of watching a school committee meeting, maybe, and how heated those can get because of what's at stake, your kid's education, versus maybe, a sewer line. Or more, what we all might be aware of is if you just think about Parliament in Great Britain and the way when you have someone speaking, including the Prime Minister, the opposing side can be up there jeering. And in many cases, that's allowed. I mean, the decorum is actually something, in my view at least, saying that you're limited to public decorum, I don't really know what that means. So that's a term that could be open to a challenge, but clearly something where you say you only have 2 minutes and everybody gets the same restriction. Or we're only going to talk about these agenda items. You can't talk about taxes because it's not on the agenda. Those are all reasonable, balanced, and if applied across the board, could be used to restrict your ability to be heard at that meeting at that time. I know that in our state of Rhode Island, there is a statute. I'm not aware of any cases that have ever been done on this statute, but it's interesting because it says that, I may not be able to find it right now, but it basically says that if you're found not to be behaving properly, the moderator, the presider of that meeting, can have you removed from it. And he can have the police physically remove you from the meeting. I didn't mean to, it's amazing that the statute exists, but remove you from the meeting and restrain you until the meeting is over and fine you for $20. In all my years of practice, I've never seen that used, but it's still on the books. And no one is, therefore, I'm not aware of anyone that's ever challenged that. But we do have laws that actually do, like that one, exist and stand for the idea that if you are at a meeting and you try to make comments when you're not invited to do so, your presence there can be affected. You can be removed if you're threatening violence, for example. You can be removed from it. You can be stopped from interrupting the proceedings of the meeting. I know I was speaking with Justin Silverman about a matter that happened very recently in Montpelier. And in that case, there was someone who was physically removed and I believe was arrested, charged with a similar type statute. And ultimately those charges were dropped. There was a lot of outcry. I know that NEFAC supported that opposition to that charge. ACLU did too, and the charges were finally dropped. But it just goes to show that there are laws out there that moderators, parliamentarians can turn to in some ways to restrict how you can participate in a public meeting.
Thanks so much, Ray. Yeah, anybody who has questions can put them in the chat. We did have two people comment. One is more of a comment. Mary wrote, "You're probably familiar with the recent Massachusetts decision regarding civility at public meetings." And then there was also a question from Vin who asked, "What's the citation for the local meeting petition?"
Okay. Yeah, I'm not familiar with all other states' cases, but you know, I do try to nose around and look at things happening in other states. So I apologize if I can't think of that one offhand. As far as a statute, this is regarding the 10% rule. Is that what they're asking about? I believe so, right? They want to know about calling a meeting. That's Title 45. Chapter 3, Section 6 of the general laws. Whenever the town council or whenever 10% of the electors of any town shall make a request in writing for the calling of a town meeting to transact any business relating to the town. And it goes on to say that to do so, there must be 10% computed on the total number of electors appearing at the last canvassed voting list of the town as having a right to vote. So if they do all sign a paper, basically a petition, that would satisfy that statute.
I think we have one more question. And Mary asks, how does Rhode Island treat serial communication by public officials on social media?
Is that a reference? Forgive me, I don't understand exactly. Is that a reference to public officials who are commenting, and there might be something to do later on topic before the body, right? So Mary, by that I think you mean, how does the law treat a public body that through some electronic means, including social media, generates an idea, talks about an idea, comes to a consensus outside of the presence of a publicly posted body meeting? Oh, good. All right. So that's very good. Yeah, that's called a rolling quorum. So anytime that there is an electronic communication directly between public bodies or any other kind of communication, you mentioned social media, but that would certainly be an electronic one, by phone, by letter, by nod, whatever. So if you have one public official, as you said, serially speaking to the next public official, who speaks to the next public official down the line, to the point where they have reached a consensus just from that dialogue that's taken place on Facebook or whatever, or by email, that would be a violation, because once they hit that quorum number, any government business they talk about is in violation of the Open Meetings Act. They have created a meeting without any notice. That's called a rolling quorum. It can also, just to give you a complete answer to that, it can be accomplished through a third party. So if I'm the chair of a board, I can reach out to Emily and tell her what I think we should do with a certain matter. She can then go to another board member and say, this is what Ray wants to do. That person can tell Emily, I agree. Emily can go to another person on the board and ask the same question. Once Emily has spoken to a majority of the board, she, through that process, has created a public meeting. Public meeting wasn't posted. Public meeting doesn't have an agenda. So it is a violation of law.
Great, thank you so much for taking the
Sure.
time to walk us through this.
Of course.
I really appreciate it.